There is a word that appears in federal court rulings exactly 0 times in the entire 234-year history of the American judicial system when describing the Department of Justice. Sloppiness. Judges don't call the DOJ sloppy. They don't use words like careless, incompetent, unprepared, because for 2 centuries, the Department of Justice, whatever its flaws, whatever its politics, whatever its controversies, has been competent. The lawyers know the law, the filings are accurate, the facts are checked, the deadlines are met. That's the bare minimum. That's not excellence, that's basic professional functioning. And the DOJ, for 234 years, has met that standard. Until now. 48 hours ago, federal judges across the United States began issuing rulings that used language no one has ever seen in judicial opinions about the Department of Justice. Words like in sloppiness, inappropriate, unlawful, civil contempt. Judge Irene Berger in West Virginia wrote that the government's conduct shows sloppiness that further validates the court's concerns about the procedures utilized by respondents in depriving people present in the United States of their liberty. Judge Torstrud ordered the Trump administration held in civil contempt for transferring an ICE detainee to Texas in violation of a court order, then releasing him in El Paso without his belongings, without identification, without money. $568 away from a plane ticket home that the judge ordered the government to reimburse. Judge McConnell ordered ICE to return property they unlawfully seized, car keys from a man and his wife who were detained and released, 75 miles from their home with no way to get there. Judge Algen in California issued an order releasing a detainee after the Department of Justice filed no opposition, no response, no argument, just silence. Because they detained someone, threw them in a detention center, and then when that person filed a habeas corpus petition, a constitutional right to challenge unlawful detention, the DOJ had no lawyers available to respond. Not because the case was weak, not because they chose not to fight, because there was nobody left to write the brief. And in the most humiliating, most devastating, most indefensible ruling of all, Judge Berger had to explain to the United States government that the man they detained for a Purdy marijuana conviction in 2009 could not possibly have committed that crime because he was 4 years old back in 2009. The government, ICE, the agency, the DOJ lawyers who were supposed to verify facts claimed a man had a criminal conviction when he was 4 years old. They didn't check the birth date. They didn't verify the identity. They saw a matching name and detained him. And only when a federal judge actually read the documents did anyone notice that the person they imprisoned wasn't even in elementary school when the alleged crime occurred. This is not an anomaly. This is not one mistake. This is systemic collapse. The mass exodus of DOJ attorneys, thousands of career prosecutors, immigration lawyers, civil rights specialists, people who spent decades learning how the system works, has left the Department of Justice unable to perform basic legal functions. They can't meet deadlines. They can't verify facts. They can't respond to habeas petitions. They can't even show up to hearings without being held in contempt. And the people paying the price, the human beings being detained in ICE facilities, thrown into camps, separated from their families, denied access to lawyers, held in conditions that violate the Constitution, while the DOJ lawyers who are supposed to represent the government in court don't even file paperwork because they literally don't have enough people left who know how. In the next 50 minutes, I'm going to show you the receipts, the actual court rulings, the contempt orders, the judicial findings that prove the Trump DOJ is in institutional collapse. I'm going to show you the cases where judges are releasing detainees not because the detention is justified, but because the government can't be bothered to argue. I'm going to show you the leaked internal assessments that reveal DOJ lawyers are being pulled from criminal divisions, from civil rights, from national security, and thrown into immigration cases with zero training and zero support. I'm going to show you why this isn't just bad lawyering. This is intentional chaos, a strategy by Stephen Miller and ICE to overwhelm the courts, to detain without due process, to create a system where detention becomes punishment, regardless of legality. And I'm going to explain what this means for the rule of law, for your constitutional rights, and for the terrifying reality that the justice system of the United States is fracturing under the weight of authoritarian incompetence. You are watching the Department of Justice collapse in real time. You are watching federal judges, conservative, liberal, appointed by both parties, issue contempt rulings, release orders, and scathing opinions because the government has stopped functioning. And the Attorney General, Pam Bondi, the person who is supposed to oversee this institution, who is supposed to ensure competent legal representation, who is supposed to uphold the rule of law, she's on Fox News talking about the economy and how Trump is making America safe, while federal judges are holding her department in contempt. Don't look away. Segment 1, the trigger. Let's rewind 4 weeks, because the DOJ didn't collapse overnight. It collapsed the moment the Trump administration began purging career attorneys and replacing institutional expertise with loyalty and chaos. Week 1, February 1st, 7th. The purge begins. The DOJ announces the termination or forced resignation of over 1,200 career attorneys. Civil Rights Division, Immigration Section, Criminal Division, National Security Division, people who have been at the DOJ for 10, 15, 20 years, gone. The official reason, restructuring. The real reason, they wouldn't participate in mass deportation legal strategy that violates due process. Week 2, February 8th to 14th. The replacement begins. According to sources inside the DOJ, military JAG lawyers, attorneys who work for the Department of Defense on military justice issues, are reassigned to immigration cases. They have no training in immigration law, no experience in habeas litigation, no familiarity with civil detention standards. They're told, show up to court, represent the government, figure it out. This is like pulling a cardiologist out of surgery and telling them to perform brain surgery. Same building, different specialty. Catastrophic results. Week 3, February 15th, 21st. The cases start falling apart. ICE is detaining people at record rates, thousands per week. Those detainees, as is their constitutional right, file habeas corpus petitions challenging their detention. The DOJ is supposed to respond within 7 to 14 days, depending on the jurisdiction. The responses don't come. Deadlines are missed. Judges issue orders demanding explanation. The DOJ files motions for extension, citing understaffing and resource constraints. Judges deny the extensions. The Constitution doesn't pause because you fired your lawyers. Week 4, February 22nd, 28th. The contempt orders begin. Judge after judge in district after district starts issuing rulings that have never been issued before. Findings of civil contempt against the United States government for failing to comply with court orders, for releasing detainees in violation of judicial instructions, for seizing property unlawfully, for making shit up. And here's the trigger, the moment that turned this from a bureaucratic disaster into a constitutional crisis. February 26th. A national conference call of federal public defenders and immigration attorneys. Over 400 participants. The topic, coordinated litigation strategy to challenge ICE detention practices. According to 3 sources on that call, the consensus was unanimous. The DOJ is in collapse. They cannot defend these cases, file habeas petitions aggressively, demand hearings, force the government to respond. They won't be able to, and judges will release your clients by default. And that's exactly what's happening. Not in one district. Everywhere. Judges are releasing detainees because the government has no argument. Not because the government's argument is weak, because there is no argument. No filing, no lawyer, no opposition. The system is breaking, and it's breaking because Trump destroyed the institution that was supposed to run it. Segment 2, the receipts. We don't do outrage without evidence. Let's look at the receipts, the actual court rulings that prove the DOJ is in systemic collapse. Receipt 1, the 4-year-old conviction. Judge Irene Berger, United States District Court for the Southern District of West Virginia, February 27, 2025. The government detained a man claiming he had a criminal conviction for marijuana possession in 2009. They submitted a document to the court showing the conviction. They argued detention was justified because of criminal history. Judge Berger read the document and noticed something the government didn't. The man was 4 years old in 2009. The judge's ruling. The respondent indicated that the document was supplied by ICE and likely presumed to relate to the petitioner because the individual in those records had the same name, despite differences in birth date, birthplace, parents' names, and immigration status. This sloppiness further validates the court's concerns about the procedures utilized by respondents in depriving people present in the United States of their liberty. This isn't a typo. This is a fundamental incompetence. ICE saw a matching name and didn't verify anything else. Not the birth date, not the birthplace, not the parents, nothing. And the DOJ lawyer who submitted that document to the court didn't check it either, just filed it under penalty of perjury to a federal judge. Receipt 2, the El Paso dump. Judge Torstrud, United States District Court, February 25, 2025, a man was detained by ICE. The judge ordered his release. Instead of releasing him where he was detained, where his family could pick him up, ICE transferred him to Texas in direct violation of the court order, then released him in El Paso with no belongings, no identification, no money. The man had to borrow a phone, call his wife, and scrape together $568 for a plane ticket home. Judge Torstrud's ruling. Civil contempt. The government violated a direct court order. The government must reimburse the $568, and the government must explain why they thought transferring a detainee to a different state in violation of a judicial release order was acceptable. The DOJ's response, according to the ruling, and administrative error. Administrative error. They accidentally put a man on a plane to Texas, accidentally released him in a city where he had no resources, and accidentally kept all his property. The judge didn't buy it. Contempt. Receipt 3, the car keys. Judge McConnell, United States District Court, February 24, 2025. A man and his wife were detained by ICE. The judge ordered their release. ICE released them 75 miles from their home and kept their back car keys. The couple had no car, no keys, no way to get home. They asked ICE for their property. ICE said they'd look into it. The couple filed an emergency motion. Judge McConnell ordered ICE to return the property immediately, calling the agency's actions unlawful and inappropriate. 3 days later, ICE returned the keys. No explanation, no apology. This is not bureaucracy. This is cruelty. Deliberate, calculated, designed to punish people for asserting their rights. Receipt 4, the non-opposition releases. Judge Algin, Central District of California, February 28, 2025. ICE detains someone, that person files a habeas petition. The DOJ is required to file an opposition within 7 days. The DOJ files what? Nothing. Judge Algin's order. At this time, respondents do not have an opposition to the arguments being presented. The petitioner is ordered released immediately. This is happening hundreds of times. Kyle Cheney, investigative journalist, documented dozens of cases in California, Illinois, Texas, New York. Same pattern, detention, habeas petition, no response, release. Why? Because the DOJ doesn't have lawyers' house to write the responses. They fired the immigration attorneys. They replaced them with JAG lawyers who don't know immigration law. And now cases are falling apart because nobody is there to argue them. Receipt 5, the contempt cascade. The chief judge in Minnesota issued a statement last week. The respondent has violated more court orders in the last month than most federal agencies violate in an entire career. More violations in 1 month than most agencies commit ever. That's not sloppiness. That's institutional disintegration. And every single one of these receipts, every contempt order, every release, every scathing judicial opinion has one thing in common: they were avoidable. If the DOJ had competent lawyers, if ICE followed the law, if the Trump administration cared about due process, but they don't. Because this isn't about law, this is about chaos. Segment 3, the psychological breakdown. Let me explain why this is happening. Not because of incompetence, because of strategy. Stephen Miller, the architect of Trump's immigration policy, operates on a simple theory: overwhelm the system, detain faster than courts can process, create so much chaos that due process becomes impossible. If you detain 10,000 people per week and each person has the right to a lawyer, the right to a hearing, the right to challenge detention, the system can't handle it. Courts get backlogged, lawyers get overwhelmed, people sit in detention for months waiting for hearings. And if you also purge the DOJ attorneys who know how to process these cases, if you replace them with untrained lawyers who don't know the law, the system doesn't just slow down, it collapses. Cases get dismissed, detainees get released, but not because they won, because the government can't function. And Miller doesn't care, because for every person released by a judge, ICE detains 10 more. The chaos is the point. The overwhelm is the strategy. Now look at the judges. Look at what institutional resistance looks like. Federal judges, lifetime appointments insulated from political pressure, are issuing contempt orders, release orders, and scathing opinions because they're the last line of defense for the rule of law. They can't stop ICE from detaining people. They can't stop Trump from purging the DOJ, but they can enforce court orders. They can release people when the government fails to justify detention. They can hold the government in contempt when it violates judicial instructions. And that's exactly what they're doing, not because they're political, because this is their job. Judges exist to check executive power, to ensure due process, to protect constitutional rights. When the executive branch stops following the law, judges enforce it. That's not activism. That's what separation of powers. Functioning exactly as designed. But here's the problem. Judges can only rule on the cases before them. They can't fix the systemic collapse. They can release one person, but ICE detains 100 more. They can hold the government in contempt, but the government just pays the fine and keeps violating orders. The judicial branch is holding the line. But the line is breaking because the volume of violations is too high, the pace of detention is too fast, and the DOJ, the institution that's supposed to represent the government competently and lawfully, is gone. Segment 4, the consequences for you. Let me make this personal. Let me explain what the collapse of DOJ competence means for your rights, your safety, your justice system, your due process. The right to challenge unlawful detention, habeas corpus, is the oldest protection in common law. It predates the Constitution. It's the bedrock of liberty. If the government can detain you and then not show up to court to justify it, that right is meaningless. You get released, sure, but only after days, weeks, months in detention, and the government faces no consequence for the violation. That's not due process. That's procedural collapse. Your courts. Federal judges are issuing orders that get ignored. They're holding the government in contempt. They're begging the DOJ to follow the law. If the executive branch can simply ignore judicial orders without consequence, the separation of powers is dead. Courts become advisory. Their rulings become suggestions. That's not democracy. That's authoritarianism. Your lawyers. The career DOJ attorneys who were purged, many of them are now in private practice representing the people being detained. They're filing habeas petitions. They're winning cases, but there aren't enough of them. For every person with a lawyer, there are 10 people sitting in detention with no representation, no knowledge of their rights, no ability to challenge their imprisonment. Your tax dollars. Every contempt order, every lawsuit, every release, the government is losing. And losing costs money, legal fees, court costs, Reimbursements like that $568 plane ticket. You're paying for this. You're paying for the chaos. You're paying for the incompetence. You're paying for a DOJ that can't do its job because Trump fired everyone who knew how. Segment 5, the domino forecast. What happens next? Let me show you the scenarios, because this doesn't stabilize, it accelerates. Scenario A, the judicial revolt. More judges issue contempt orders. More detainees get released. The DOJ, unable to defend cases, starts dropping charges, withdrawing oppositions, conceding releases to avoid further contempt findings. ICE's detention operation becomes legally untenable, not because of policy, because the legal infrastructure to support it has collapsed. Congress is forced to intervene. Oversight hearings, subpoenas, demands for accountability. The DOJ is forced to rehire purged attorneys or face total operational failure. Scenario B, the ICE workaround. ICE, frustrated by judicial releases, stops bringing detainees to immigration court. They start transferring people to other jurisdictions before hearings can occur or deporting them, before lawyers can file habeas petitions. This triggers a new wave of litigation. Lawyers file emergency motions. Judges issue nationwide injunctions. The legal war escalates. But in the meantime, people disappear, deported without hearings, transferred without notice. The chaos becomes a feature, not a bug. Scenario C, the constitutional crisis. The Supreme Court is forced to intervene. Cases reach the High Court challenging the mass detention practices, the DOJ's contempt violations, the executive branch's refusal to comply with judicial orders. The court sides with the lower courts, issues a sweeping ruling reaffirming habeas rights and judicial authority. Trump ignores it. Issues a statement saying the court is wrong and ICE will continue operations. The executive branch openly defies the Supreme Court. The constitutional separation of powers fractures. We enter uncharted territory. Segment 6, the verdict. Let me give you the image. Somewhere in a federal courthouse, a judge is reading a filing from the Department of Justice. The filing claims a man should remain in detention because of a criminal conviction. The judge checks the dates and realizes the man was 4 years old when the crime allegedly occurred. The judge doesn't laugh, doesn't roll their eyes, just writes carefully, precisely. This sloppiness further validates the court's concerns. Sloppiness, the word that never appears in judicial opinions about the DOJ until now. That judge is watching the institution they've worked with for decades, the Department of Justice, the lawyers who are supposed to represent the United States with competence and integrity, fall apart. And that judge is doing the only thing they can do: enforce the law. Release the detainee, hold the government accountable, write the opinion that documents the collapse for history, because someone has to. Someone has to stand up and say, this is not normal, this is not acceptable, this violates the Constitution. The judges are standing. The question is whether anyone else will join them. Before I close, call to action. I want to hear from you. Are federal judges right to hold the DOJ in contempt? Is this systemic collapse or intentional chaos? And what should happen to the officials who purged the attorneys and created this crisis? Comments. Now, I read every one. This channel covers the stories corporate media ignores, the contempt orders, the habeas victories, the judicial resistance. Subscribe and share. Special thanks to Harry Littman and Talking Feds for the legal analysis. Check out Harry's YouTube channel and his upcoming event with Governor Josh Shapiro on March 14th in San Diego. The DOJ is collapsing. Judges are fighting back, and the rule of law hangs in the balance. Don't blink. More contempt orders are coming, and everyone is a signal. The courts will not surrender, even if the executive branch already has.